My name is Lawrence Daly. I am a forensic child sexual abuse investigator, interviewer, and educator. The following is going to be a diagram on the investigations and interviewing of an investigative child sexual abuse interview. There will be criteria that I want you to consider when you investigate or interview child sexual abuse allegations. There are no such thing as coincidence when dealing with an allegation of child sexual abuse. Wrong target. What role does coincidence play in child sexual abuse investigations? If enough perpetrators are interrogated, some of them will appear to be guilty. A few people will just be in the wrong place at the wrong time. Efforts to solve a crime by working backwards, that is, from the suspect to the crime, rather than from the crime to the suspect, are possibly suggestible to errors of coincidence. It can happen to anyone. It happens every day in the criminal justice system. A person is accused of committing a crime, only too late to discover that the alleged victim was wrong. The question the law enforcement child sexual abuse investigator needs to ask in every investigation is: 1. Do they have the correct perpetrator? 2. Is the crime alleged physically possible? 3. Is there an improper motive for the alleged perpetrator to be identified as the wrong target? Skeptics. Skeptics often say they do not believe in coincidences. However, when looking for patterns within large number of items, that is, events, suspects, coincidences are inevitable. The law enforcement child sexual abuse investigator must be able to mentally handle the challenges which are presented when dealing with an allegation of child sexual abuse. One of the mental strategies which the investigator will face is skepticism, which is a provisional approach to claims. It is the application of reason to any and all ideas. No sacred cows allowed. The law enforcement child sexual abuse investigator should be skeptic about the allegation, not as a denial that the allegations aren't true, but to us it is a method to critically think about skepticism, which is a method, not a position. Ideally, law enforcement child sexual abuse skeptics do not go into an investigation closed to the possibility that a phenomenon might be real or that a claim might be true. When an investigator states they are skeptical, they mean that they must see compelling evidence before they believe the allegation is true or false. Respected. When law enforcement child sexual abuse investigators take charge of their careers and conduct thorough, complete, and competent child sexual abuse investigations, there are no coincidences when these type of investigators find success in finding the truth. It is that criminals are generally not masterminds. In child sexual abuse allegations, although the range of pedophiles' occupations can range from a Boeing engineer to a carpenter, the child sexual abuse investigation needs to be straightforward. The majority of alleged perpetrators want to confess to committing the incident. The investigator needs to open the door and let the perpetrator in so he or she can confess to the allegation, which were made against them. Supervisors of the law enforcement child sexual abuse investigator should encourage and respect his or her investigator alternative explanation for his or her findings, as a gut reaction based on feelings may be the difference in arresting and criminally charging any and all individuals. On occasion, a law enforcement child sexual abuse investigator will take a position in the case he or she is investigating which may be found to be against what other professionals believe what actually took place. It is a curious conflict which occurs behind closed doors where the investigator states he doesn't believe the alleged victim and witnesses. This is a difficult position to be placed into, playing the role of the devil's advocate. The law enforcement child sexual abuse investigator may have to turn to the child sexual abuse experts who can provide their opinion on the facts as they have been presented. There is no coincidence that a trier of the facts should be able to conduct the pinch test. That is, to make sure they are using their critical thinking skills to come to the complete, thorough, and competent decision about the investigation. Intrigued. Coincidences fascinate law enforcement child sexual abuse investigators. The investigators seem to compel a search for their significance in a child sexual abuse investigation. More often than some people realize, however, they're to be expected and require no special explanations. Coincidences can be a trap when perpetrators' modus operandi and similar fact evidence are used for child sexual abuse crime linkage purposes. Law enforcement child sexual abuse investigators need to make sure they don't get trapped into data and refuse to use common sense. Law enforcement child sexual abuse investigators working high stressful child sexual abuse cases are often confronted with the roller coaster situation, where the ups and downs erect barriers, boundaries, which cause the investigator to detour from their eventual correct hypothesis. When biological and physical evidence is located at the crime scene, this is not a coincidence when the law enforcement child sexual abuse investigator evaluates the evidence of the alleged crime. They must consider what conditions were necessary for certain aspects of the crime to be possible. Therefore, examining and evaluating the evidence is a must. Coincidence, also known as similar fact evidence, shows that conduct in other occasions is too similar to conduct with which the accused is charged. When conducting a crime reconstruction, there are a long line of necessary investigative steps and forensic processes utilized in order to identify the value of the evidence. It is not a coincidence to find specific evidence at a crime scene, such as cigarette butts, beer cans, pop bottles, and so forth. Evidence. When collecting evidence at a crime scene, the law enforcement child sexual abuse investigator must take steps to identify that physical evidence is at the crime scene because of a coincidence and or evidence at the actual crime and or both. A law enforcement child sexual abuse investigator should take the following steps to determine coincidence, foreign and or other evidence of a crime. Number 1, protection from the environment and those in it. Number 2, documentation, notes, sketches, photos, videos, and etc. Number 3, collection, packaging, marking. Number 4, preservation before delivery to the lab and in the lab. Number 5, transportation to the forensic lab. Number 6, identification as a general kind of evidence based on its properties. Number 7, comparison to knowns, unknowns, and controls. Number 8, individualization as a unique piece of evidence. Number 9, interpretation, consideration with other evidence from the case. Number 10, disposition, storage, destruction, loss, deterioration. Context. When the law enforcement child sexual abuse investigator conducts a child victim interview and the child is able to provide a context of the sexual abuse incidents, this is not a coincidence. Law enforcement child sexual abuse investigators must strike a balance between stability and responsiveness. This is difficult when there is limited resources and unexpected consequences. A law enforcement child sexual abuse investigator needs to know where they received their information, i.e., a foundational base. There are 3 factors they must consider. 1, what they know, facts. 2, what they think they know, alternative hypotheses, theories, assumptions, conjecture, and so forth. And 3, what they would like to know, facts which are yet to be discovered. Maybe the law enforcement child sexual abuse investigator should be asking, how do we know what we know? And who and what along the way was our greatest witness, piece of evidence, hypothesis, inference? Recognition being given to all of the factors uncovered in the investigation that the alleged coincidence was indeed not just a theory, but a theory based on actual facts which appeared and supported that a crime was indeed committed by the perpetrator, who in his or her denial proved to be the one who could his or her own demise by lying to all the parties involved in the case. Fact. If it turns out there is a reason for the fact, then there is no coincidence. When examining, evaluating, and documenting alternative hypotheses in the investigation of an allegation of child sexual abuse, this may establish, create, expand, and facilitate a systematic process which can protect an investigator from establishing credibility in the investigation. This may occur when an idea or theory gains credence from the possibility and the passing of time, rather than from supporting evidence. A possibility solidifies into a probability and then crystallizes into certain facts. Most law enforcement child sexual abuse investigators do not understand what a coincidence is and how it correlates with a fact. Supporting the two may be significant to the child sexual abuse investigation. The facts, if examined and evaluated properly, can demonstrate some coincidence. However, the fact that an act occurred may seem like a coincidence. In the end, it may be just a fact which is ever present and identified by the investigator. Actions. There is one thing that many law enforcement child sexual abuse investigators learn eventually. It is that their actions carry with them may be a coincidence. Some law enforcement child sexual abuse investigators have great difficulty in thinking outside the box. When this occurs, there is a reluctance on the part of the investigator to think critically and question the main theory of the child sexual abuse allegation, leaving the investigator with an imminent decision to be made in the immediate future. It is a fact that the specific actions one takes is sometimes not a coincidence, and the steps a law enforcement child sexual abuse investigator pursues, the residual effect may not be immediately felt by those involved. Therefore, the unexpected may occur during the investigation, and the investigator must determine how the actions taken by the witnesses are coincidental to the events or the alleged crime or the information which was always ever present. The investigator just not enhancing his or her ability to locate and implement the actions of all those involved in the alleged crime. Body parts. When a child can describe the private parts of the perpetrator who committed the child's sexual abuse, this is not a coincidence. It is not a coincidence that a child is able to discuss and produce adult concepts and words which only an adult should have knowledge of. It is not a coincidence that a child is able to describe the statements in which the perpetrator made before, during, and after the sexual abuse, i.e., threatening the child with harm of his or her parents, and so forth. When the law enforcement child sexual abuse investigator is able to obtain a 70% confession rate in all of their child sexual abuse investigations, this is not a coincidence. Competent. When the law enforcement child sexual abuse investigator is able to close out his or her child sexual abuse cases with a 90% success rate, this is not a coincidence. The witnesses in the child sexual abuse case initially believe everything they see and hear. Seeing is believing. But then rapidly assess whether it is true or not, and consequently reject or continue to believe things. This assessment and decision takes time and energy, so the more tired people get or more distracted by other things, the more they are likely to believe false information. This is unforeseen coincidences. The child sexual abuse investigation is the most important aspect of the criminal justice system. When properly and competently investigated, the victim and perpetrator will find the truth to be justified. This aspect of the process is not a coincidence, not an arbitrary decision or action and random act. It is, in fact, one of the main journeys in finding the truth. Thank you.